All right, let's go ahead and get started. I kind of feel alone this morning. Where's everybody at? Thank you, all of you, for being here. Let me do a couple of housekeeping matters before we get going. Somebody reminded me last night that this is not Nebraska, and so therefore I need to make some subcommittee assignments of bills that have been passed out of the other chamber. I don't anticipate subcommittees will start meeting until next week on these bills, but Senate Bill 1 is assigned to Subcommittee 1 by Chairman Knox. I previously had already assigned Senate Bill 23 to Subcommittee 2, the Mumford Subcommittee. That's already there. Senate Bill 24 is assigned to the Mumford Subcommittee. Senate Bill 54 is assigned to Subcommittee 1. Senate Bill 95 is assigned to Subcommittee 2. Senate Bill 97 is assigned to Subcommittee 1. Secretary Bearden, I'm going to ask you to look at, this is not an assignment, but to look at Senate Bill 40, which appears to be somewhat similar to your bill, and if on elections, and if it is, I'm not sure we need to take it up, but would you report back to me on that? Now, let me kind of tell you our time frame before we start today. We spent yesterday from about 11:30 until about 5:30 on House Bill 185, which I think was appropriate given the subject matter and a very, very serious issue. We are planning to meet this morning. We're going to complete this morning no later than 11:45 due to some other committees that are meeting this afternoon. I will spend as long as you want on these bills, but what we're not able to finish, we're going to come back at 3:30 today. These bills have been through the subcommittee process, and I think have been given good hearings. So be guided accordingly by that. Finally, and most importantly, I want to recognize the judge of the day, my former colleague from the Senate, now Judge Billy Ray from Gwinnett County. Judge Ray, we're pleased to have you with us today. Thank you for being here. Okay, we're going to start by taking House Bill 92. Representative Everson. Representative Everson.
Thank you, Mr. Chairman and members of the committee. I do want to thank you for hearing House Bill 92. House Bill 92 was before this committee last year in the form of House Bill 1167. And House Bill 92 basically is to repeal a law that was enacted in 1981 which prohibits professional cosmetic technicians from performing micropigmentation 1-inch from the eye socket. Georgia is the only state in which this is a misdemeanor. And points for House Bill 92, these individuals are properly educated, permanent cosmetic technicians that are being allowed to perform this procedure within 1 inch of the eye. Georgia, as I stated, is the only state that prohibits permanent cosmetic technicians from doing this. Permanent cosmetic procedures are not taught in medical school, and they fall outside of the scope of practice for medical doctors. These professionals are pro-educators, and reasonable regulations are in place to protect the safety of the patient. And this will authorize them to perform that procedure. and I do have a few of them that are here today to speak on behalf of this and in favor of this, and I have not received any opposition to this via email, but I was informed that there might be some opposition coming before you today, and I am willing to hear what they have to say. Each of you should have received a handout yesterday in regards to this. I think it's a right step for us to take. Personal responsibility, less government, and it allows these individuals that are qualified, certified, and trained to perform this procedure the right to perform this procedure for their customers. And I will entertain any questions that the committee might have, and if I'm not able to answer those, I have some individuals that are here that are more qualified to answer those questions. Thank you, Mr. Chairman.
Thank you, Representative Everson. Questions from the committee for the author, Secretary Bearden.
Representative Everson, I'm sorry, I walked out the room for just a moment. When did the prohibition go into place?
1981.
81. Okay. Thank you.
Is that it? Vice Chairman Mumford.
Representative Everson, this is the same bill that passed through this committee last year?
Yes.
And it passed through the House. This bill passed through the House last year.
Well, it was going to go to the floor of the House, and I found out I was in error in that it didn't make it. It died because of lack of time. Couldn't get through in time. Yes.
But it's the same bill.
Same bill. Same bill. No changes, no amendments.
All right.
Further questions from the committee? Representative Randall.
I'm not sure if this is as much of a question as a comment. This is an issue that has been introduced before to repeal this, and it's good legislation because of. I hope that you all had a chance to look at the information that he gave out yesterday. I was chair of the subcommittee on health when it came through, when Representative McClinton made an attempt to repeal it as well, and it got soiled in the Senate and did not pass. But I certainly recommend support of this bill from my committee members, and I hope that you all had an opportunity to read the information surrounding this bill, because it's very, very important to those victims of various complications that they've had personally with their health complications, and I certainly recommend do pass, and would like to be recognized at the proper time for a motion.
If you'll remind me, Representative Randall, I will certainly do that. We have
Absolutely.
a few people that have signed up to speak. Any further questions from the committee for the author? If not, I will recognize we have, looks like 5 people have signed up to speak on this bill. Barbara McClure. Come around, Ms. McClure.
Thank you, Mr. Chairman, and thank you, Representative Randall, for the support. I'm Barbara McClure, and I'm in strong support of House Bill 92. I am a certified permanent cosmetic professional for 13 years. I am also a many more years than I'd like to mention, registered nurse that is practicing and licensed in the state of Georgia. The first thing that I'd like to say is that my colleagues and I are strongly in favor of the health and welfare of our clients and the constituents in Georgia. We are in favor of educational requirements and standards and reasonable regulation for such services, and currently we are regulated under the tattoo laws of health and human resources, and each county individually under their boards of health have their regulations, and then they of course go to the state. We are also regulated by 2 international organizations, the Society of Professional Cosmetic and the American Academy of Micropigmentation. Both of these have national certification programs, that they have standards of practice, ethics. In order to belong, we are self-monitoring. We have to have continuing education to continue to be certified, and including courses on blood-borne pathogens and etc. The issue is that because only physicians are allowed to tattoo at this time within 1 inch of the eye, there are many people that are being unable to even acquire the procedures in this state and are having to go outside the state. This is the only state that does not allow permanent cosmetic technicians to perform this procedure within 1 inch of the eye. And like I say, Florida, Alabama, South Carolina now passed their bill about a year ago. So people are going out of the state to be able to acquire these procedures. These are not procedures that are just done to look good. Yes, people like to look good and look their best, but they are procedures that are done for purposes such as women who are suffering from cancer and getting ready to go into chemotherapy. They want to look their best, and if they're going to lose all the hair, they want to at least have their eyebrows apparent or their eyeliner so that they can look like they still have features. Women with Parkinson's disease, with MS, with neurological disorders, loss of sight, these people cannot put on their cosmetics, and they want to look good, just the same as everyone else, and our society puts a high priority on how we appear in the public. Also, people who suffer from a condition called alopecia, which you lose your hair. Some people lose all the hair on their body. Some of them only lose the hair on their faces, their eyebrows or their eyelashes. So this is something that is very important to them to be able to have a normal appearance. Actually, there's probably less than even 0.5% of physicians in the state of Georgia. We only know of actually one that may actually be able to do this procedure, and it is actually outside their scope of practice. They are not taught tattooing in medical school. In fact, those that have learned have had to go and learn from a permanent cosmetic artist to be able to do the procedures. There was a national survey that just came out. It was done in 2006 by the SPCP organization, and it states that nationally, only 1.4% of all of permanent cosmetic procedures are even done by physicians. So it is not a high priority for physicians to do this. They don't want to do it. On the whole, it is not economically in their favor to do it. It's time-consuming and requires a special procedure to do it, and they need to do more important things that are curing people, not applying makeup. The procedures are safe. We have documentation that's in your packet concerning the insurance companies that have long insured these procedures, and there's actually, in 20 years, was only one incidence in which there was a corneal abrasion that was reported to the insurance company. And a corneal abrasion is something that within 24 hours heals and is easily taken care of. I'm not going to take a lot of your time because things have gone a long time. I have a few more things, but we have other people that want to speak. But I also wanted to kind of give you an idea of the average person that is asking for our services, other than being in medical need, but they are usually women. They're often between the ages of 40 to 55, so they're not young girls out there frivolously deciding to have some kind of body art. The people that most often perform these in their backgrounds, other than the fact that they are professional cosmetic technicians, about 36% of them were estheticians, 23% of them were cosmetologists, about 10% were nurses, and only about 23% are even done in a doctor's office. They are done in private offices, practices, etc. for this procedure. And so I'm asking you to consider this strongly and allow for properly educated permanent cosmetic technicians to provide the services regulated under the state and the county health resources boards.
Okay. Thank you very much, Ms. McClure. Questions from the committee? Questions from the committee? Thank you very much. Do you have others here that are favoring the bill?
Yes.
Okay, and they all wish to speak?
Yes, they're going to have some little different issues.
I would ask them if they would to confine their remarks to matters you did not cover.
Right.
so we can avoid being repetitive, okay?
Okay, great.
Connie Massey.
Thank you, Mr. Chairman. My name is Connie Massey, and I'm board certified by the American Academy of Micropigmentation and a member of the Society for Permanent Cosmetic Professionals. After spending 20 years as a dental assistant, I began applying permanent cosmetics in 1998 while living in Florida. When I returned to Georgia in 2002, I was surprised to learn that Georgia law would not allow me to provide all of the services in which I was trained. I have been a breast cancer survivor for over 5 years. I've had a double mastectomy and subsequent reconstruction. I know what it means to go through the ordeal of cancer. I was fortunate to have cosmetic tattooing available, which helped me to cope with the emotional aspects of treatment. A large part of my practice in Georgia includes the finishing touches of breast reconstruction. This involves repigmenting the areola complex and revision and camouflaging scars left from surgery. In other states, we can also work with a person prior to chemotherapy to maintain their features by implanting pigment in the eyebrow area to simulate hair and around the eyelid to maintain definition. When they lose their hair, they don't have to lose their facial features. Society focuses on appearance. We want to look our best, or at least normal while we're going through treatment. These procedures are done in such a way that when, or if, the hair grows back, it will work with the implanted pigment. I ask that you vote yes to pass HB 92 so that properly trained and certified technicians can provide these important services.
Thank you. Thank you much, Ms. Massey. Questions from the committee? Representative Byrd, if you'd stay with us, Ms. Massey. Thank you.
I have those as examples of procedures that can be done.
Representative Byrd.
How much training do you go through to get your license?
First, there is no licensure for this. It is a certification. Currently, the SPCP recommends a minimum of 60 hours training. We also recommend that a person stays under the apprenticeship of their trainer for at least the first year.
Thank you.
Further questions? Further questions? Thank you very much, Ms. Massey. Janet Wicks.
Good morning, ladies and gentlemen. My name is Janet Wicks, and I too am in support of House Bill 92. And I don't have a prepared document to read to you, so I'm going to speak from my heart. I'm not sure if you know, and I'm very compassionate. I've worked with older people for many years, and as I start to age, and as I see my parents age, and friends and those that I love age, you know, my heart reaches out to them because we always want to restore our youth. I've worked many years in the corporate world, and one of the focuses that I have are, and many people that I've worked with are stroke victims. And when you have loss of use of part of your body, sometimes your face is what you have left. And it is an honor to me to be able to restore someone's dignity and their sense of self-worth and self-esteem. In addition, recently, I've been working with a young African-American male who spent 20 years in the military, and he was around jet fuel for over about 12 of those years, which caused vitiligo, splashing of the arms. It is in his eyebrows and along his hairline. And this young man, it just wrenched my heart because he fought for our country, and he wants to be normal, and he wants to fit in and be normal and appear normal. So he goes through dyes. He dyes his skin just to recover some of that. This practice is not relegated just to women, but there are males that have impacted. And I don't think that I've ever been so heartfelt touched other when I did this young man not too long ago. Since then, he's called and he said it's absolutely changed his life, because now he was having to conceal his eyebrows, his hairline, just to go out in public. And if he ever went out where he had no pigment at all, it was so embarrassing and people would stare. And he said his quality of life has gone, 180 degrees in the other direction. On that, I just wanted to say one more thing. When we perform micropigmentation, the needles that we use are half the depth of this dime. They are barely out just enough to prick the skin and deposit a little pigment. And so you can see how a dime is so incredibly thin. I just wanted to bring that point out as well. You know, we're here, our physical appearance is paramount to us. And I just ask you from the bottom of your hearts to reach out and hopefully you've not had anyone in your walk of life that has had to go through some of the tragedies and the afflictions that have. And it does help people who aren't afflicted as well with various diseases or, you know, impairments. But I reach out to the ones that it has touched, and it has touched me, and I'm a changed person. So please support House Bill number 92.
Thank you very much. Questions from the committee? Mary Tooker.
Morning, everyone. I will only add comments about my own personal history. I'm a registered nurse, and I'm not ashamed to say that in May of 2006 was my 30th year of celebration as a nurse practitioner. I have clinical specialties in surgery and in OBGYN. My interest in medical micropigmentation began 10 years ago by having my own makeup applied so that I could be in an operating room at 7 o'clock in the morning and look fairly acceptable. I saw the implications of this profession, other than the pretty side, when my office was 5 blocks away from the Alfred Murrah Federal Building in Oklahoma City, and was impacted by the people running away that day with facial injuries due to glass and burns. And I saw how reconstruction processes can be very important. That added a whole new impact to my profession. It is not just about making people pretty. It is about creating or restoring their dignity after cancer, burns, accidental injuries, or disease processes, as my colleagues have told you. I have both basic and advanced training in application and reconstruction. I've been a dues-paying insured member of both of our professional societies for 8 years. I am an international certified instructor. I have done and taught thousands of these procedures within 1 inch of the eye, without any adverse results or injury. And as an instructor, I agree to contribute yearly articles to my professional organizations, to participate in ongoing education, and also to provide ongoing technical support to my colleagues and my students. I worked with the Oklahoma State legislative process to serve on the Oklahoma State Board of Micropigmentation, worked with Governor Frank Keating and also Brad Henry to recognize our profession in Oklahoma. I moved to Georgia just 1 year ago, and at that time I found out the full impact of this old law and legislation, and as a result of that, I work now only in semi-retirement as an operating room nurse again, because I'm not able to practice the profession I've done for 8 years full-time. So, in summary, after 8 years, I've taught many physicians, but none of them perform these procedures. They do not do them themselves. Most of them take the training in order to be able to work alongside a staff member that they delegate it to. In my practice in Oklahoma City, I received direct referrals from the Dean McGee Eye Clinic from physicians who wanted their patients to have these facial procedures. We are trained professionals. That's what I'm trying to get across to your board today. And I would just like to accept any questions that you have, but basically, in summary, ask for a yes vote for this House bill so that we can give the right to work for people who are qualified to perform these services on the citizens of the state of Georgia.
Questions from the committee? Questions from the committee? Thank you very much.
You're very welcome.
Pam Daniel.
Everything has already been said, and I don't think I need to get up in the middle of it again.
Thank you very much. You get brownie points for that. Mark Baggett. Mark Baggett. Anyone from the Medical Association of Georgia with whom he was affiliated? you have any final comments while we wait on Chairman Franklin's return, Representative Everson?
I don't want to belittle or belabor the issue. I think everything has been said, but I would urge the committee members to vote favorably for this legislation to give the citizens of Georgia the right to have those individuals that are certified, trained, and educated to perform this much-needed service for the citizens of Georgia.
Thank you very much. Representative Levitas.
Mr. Chairman, I just want to applaud Representative Everson for bringing this legislation. After I read the bill, I contacted a few friends of mine, one of whom is a plastic surgeon who specializes in things like breast reconstruction and cosmetic surgery for victims of breast cancer, and she couldn't think of a reason in the world why we wouldn't want this bill to go forward for just the reasons that have been stated today. So I just want to applaud the representative for bringing this bill.
Thank you. Representative Levitas.
Any further comments? Representative Floyd, if you'll be on guard, you're next. I told Chairman Franklin I would wait. If he's out there, we'll wait. If not, we're going to vote it. Any further questions or comments? Recognize Representative Randall.
Thank you, Mr. Chairman. I move do have House Bill 92.
Second.
We have a motion that House Bill 92 be given a due pass recommendation. Is there any discussion on the motion? Any discussion? Hearing none, all in favor of the motion, please indicate by raising your right hands. Get them? Okay. All opposed, same sign. Motion carries. Thank you, Representative Everson. This will be reported to the Rules Committee.
Thank you, Chairman and Committee. Thank you.
Call House Bill 415. Representative Floyd. Representative Lane will be on deck.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, House Bill 415 is a bill that's brought by the department. House Bill 415 tries to put the same driving and DUI driving under the same as the federal code and the same rules and regs and everything. And I have with me an attorney here from the department that will go through and explain the meat of the bill if anyone has any questions on it. Thank you, Mr. Chairman.
Thank you. I think we'll wait, if it's okay, Representative Floyd, and just do questions for all you and the presenters at one time. So you're recognized.
Thank you, Mr. Chairman. Just for purposes of clarification, this is we're operating from the subcommittee's substitute, which is LC 341142S, just so that we're all.
And this comes after some rather extensive discussion the last time this bill was here. Is that correct? And have those concerns, does this sub attempt to address those concerns?
This is the same version that was discussed previously, and it's my understanding that everything has been resolved.
Okay.
Mr. Chairman, Section 1 just briefly deals with our issuance of licenses and identification cards to non-citizens. If a federal immigration document does not have an expiration date, it will be limited in issuance to just 1 year. Section 2 deals with the issuance of licenses to folks coming from out of state and just limits that the department will not issue a license to anyone whose driver's license or driving privilege is suspended or revoked in another jurisdiction. Section 3 amends Code Section 40-5-57 and provides that each offense is treated separately for the assessment of points. Section 4 deals with our teen drivers. It clarifies the penalty for them for DUI convictions. It also makes the language dealing with administrative license suspensions identical to that applies to adults. There's not a substantive change, it's just clarification. And then the amendment to paragraph D clarifies that also the teen driving offenses are each counted separately as they're treated for the adults. Section 5 deals with suspensions imposed for convictions for drug offenses. This is putting language back in that we took out in 2005. At the time that we asked the General Assembly to take this language out, we didn't realize that we were putting ourselves out of compliance with federal law, so we're putting it back in to get back into compliance with federal law. Section 6 allows the department to begin renewing identification cards. Under the current law, if you lose your identification card or you move to a different address, you essentially have to start the process over and you're issued a new identification card for the full renewal period at the full fee. This would allow us to issue replacements and renewals, which is much more customer friendly. Section 7 deals with the governor's initiative, the Secure ID initiative. This allows the department to double the number of investigators that we can hire. Obviously, the actual number will be limited through the budget process. And happy to answer any questions that the members have.
Questions from the committee? Hang on one second, Chairman Franklin. Mr. Hammond, did you want to add anything? Or
no, sir,
okay. All right, good. Chairman Franklin.
On the Section 7, you talked about the Secure ID. Is this akin to the Federal Real ID Act?
No, sir. It's actually not related to that at all. The governor's Secure ID initiative was an effort to enhance the department's ability to investigate allegations of fraud with our customers, particularly those who are from other countries and bring in fraudulent documentation, trying to prove that they're someone that they're not, or that they're in the country lawfully when they are not. It is not in any way connected to the Federal Real ID Act.
And if I could ask another question, is there a, or if you could point to the provision in here that would allow someone who's in the country illegally to obtain a driver's license or ID card?
There is nothing in this bill that allows for that, and there is nothing in Georgia law that allows for that.
Thank you very much.
No. Representative Collins.
Thank you, Mr. Chairman. Just a few questions, and I see how this is corresponding to the federal act. There was some concern I had, especially Section 1, line 18, pending an approved application for asylum in the United States. As you're probably aware, asylum hearings can take 4 to 5 years, and you've got some that are actual, why, is there a possibility here that we could take approved asylum grants as opposed to some that are going to turn out as frivolous, for whatever reason, and separate those two, or was that something that went into the thought process here?
The language that you're referring to in line 18 is not the department's language. That's from House Bill 577 2 years ago. That's the current code.
Okay.
That's not something we're changing.
Okay, well, that's one, but I'm asking from a question perspective, not whether it's
Okay,
or not now.
I'm sorry. It certainly could be done, where we would separate the folks who have pending asylum versus those who've actually been granted asylum. But, Representative, I think that this bill actually probably addresses your concerns, because these customers are having to come in every year, so we're rechecking annually. What's the status? Has your status changed? And if in fact their document has been granted, they're not going to be coming back for a year. They're going to be coming back for the period of time that their asylum documentation allows for.
Follow-up, Mr. Chairman.
Okay. This one.
Mr. Chairman, for follow-up.
Yes.
I think you brought up something, just a question. Overall, I'm just asking just some simple questions. That I wrote down. Does this apply, or is it true that a full-time student or exchange visitor here who is currently, has duration of status on their I-94 and they're working this through, does this bill require them as a student to come back every year and get a new license?
No, sir. I don't.
That's the way it seems to read, and I was questioning that.
This bill only says that if the documentation issued to you, your immigration documentation, does not have an expiration date, you have to come back every year. If your immigration documentation has an expiration date, then we're going to make the term of your license or your identification card expire on the date that your immigration documentation expires, unless that date exceeds the maximum number of years that we can give you.
Okay. And one, that may cover it. Thank you very much. Thank you, Mr. Chairman.
Thank you. Further questions from the committee?
got a question.
Vice Chairman Mumford.
Under Section 2 in subcommittee, there was some concern about the suspension of driver's licenses, where you might have someone who's got for instance, a New Jersey license has a 10-year suspension. They can move here, live here for 8 years, and they're still eligible for a Georgia license under your current policy, I think is what it is. You're asking to put that policy into the code in Section 2?
The language that we're adding is what we believe codifies what has been the legislative intent up until this point. There was an appeals case, Roberts versus Burgess, that read the code section more narrowly and indicated that the department was only prohibited from issuing a driver's license if the state that has imposed the withdrawal, the suspension of the revocation, is that person's home state. And it has been our understanding institutionally for the years that we've been doing this that that was not the legislative intent, and so we've gone back and written this so that it covers operationally what we've been doing for as long as we've existed.
But the result of Section 2 would be that, for instance, someone who has a 10-year suspension in New Jersey might have been a resident of Georgia for 8 years and would be still ineligible for a Georgia license, even though they could have nothing longer than a 5-year suspension under Georgia law.
Correct.
Further questions? Further questions from the committee? What's the pleasure of the committee? What's the pleasure of the committee? Secretary Beard. We have a motion, or we have a move. Is there a second? We now have a motion that House Bill 415 be given a due pass recommendation. Is there any discussion on the motion? Any discussion on the motion? If not, all in favor of House Bill 415 being given a due pass recommendation, please indicate by raising your right hand. I'm sorry, by committee sub. Let me restate the motion. All in favor of House Bill 415 being given a due pass recommendation by committee sub, please indicate by raising your right hands. All opposed, same indication. Motion has been carried. Thank you very much. Thank you, Representative Floyd. Representative Lane, House Bill 599.
Thank you, Mr. Chairman, members of the committee. I bring you House Bill 599, which is a bill directed at foster children adoptions. These are children who've been through the legal process, placed in foster care, and are ready to be adopted. Either the parental rights have been terminated or surrendered, and the children are in foster care. Under current law, an adoption petition is filed in Superior Court. There's no time limit set for the filing of the adoption petition. And Superior Court then will set the final adoption hearing, but there's no deadline for the time that the final adoption hearing has to be set. They do try to expedite the adoption hearings, but there's no definite timeline involved. Therefore, it can be many months sometimes before a foster child learns whether or not they've been adopted, and they're subject to defects moving them around during that time, and a lot of uncertainty on the part of the children. So this bill is an attempt to bring some certainty to foster children as to their relationship, as whether they're going to be adopted by the current families, and to expedite that so that we strengthen the family unit. The bill, I can go through each. Section 1 of the bill, I think there's a substitute that came out of the subcommittee, which is what we'll travel under. I don't have a copy of this. I assume there's a substitute. There we go. I've got one, man. Thanks. Section 1 of the bill confers...
Representative Lane, just so we're all clear, are we working off 2806S?
That's correct, Mr. Chairman. Section 1 of the bill confers concurrent or alternative jurisdiction for adoptions for foster children in juvenile courts under very limited circumstances. The juvenile court can hear an adoption petition provided that the juvenile court has previously entered an order terminating parental rights or has entered an unexpired order finding a child deprived and the parent has voluntarily surrendered their parental rights, and that the date set by the Superior Court for a final hearing of the adoption petition is not within 30 days. If there is a hearing set in Superior Court that is within 30 days of the filing of the petition, then juvenile court would not have jurisdiction to take the case. But if it's set for longer than that, then under House Bill 599, the petition could be transferred or dismissed and refiled in juvenile court for a hearing to be held within 10 days of the filing in juvenile court on the final adoption. So it's very limited circumstances that juvenile court would ever have one of these cases, but it would be in cases where the Superior Court could not get to a final hearing or set a final hearing within 30 days. Then another important part of the bill is Section 2. Under the current, and this amends a current law. Under the current law, there's really no time limit for filing the adoption petition, and we are amending that to require that the petition to adopt the child must be filed within 4 months after the date of the disposition order from the juvenile court, unless the Department of Human Resources has not approved it yet or determined it's not in the best interest of the child that the petition be filed at that time. The remainder of the bill is simply cleaning up the language to remove language that says exclusive jurisdiction in Superior Court to allow for the provisions of this code section to give concurrent jurisdiction under these circumstances. This bill is good for foster children. It brings some certainty to their situation, and I would encourage the committee to do pass the bill. There are some folks here who probably want to speak on the bill. Yes.
Okay.
Take any questions.
Well, let's first take questions for the author. Do you have a question?
Mr. Chairman.
Chairman,
thank you. I'm just looking at Section 1, and I'm looking at the basic qualifications that will are events that will set this new process in motion. Is this the current law from line 16 down to 25, or is this new law? Is this new language?
This is all new language.
Okay. I guess my question is, there's a big difference here between a proceeding where the parental rights have been terminated and one where there is simply a deprivation proceeding pending. There are all kinds of deprivation proceedings that DFACS brings. Some of them meritorious, some of them maybe not even rising to the level of capricious. But so I'm wondering if we should, if we need to allow this event to occur where we have only a deprivation proceeding pending rather than having had a termination of the parental rights. I can see where there might be some interest in being able to allow the juvenile court to have concurrent jurisdiction, although I'm not a big fan of that, but allow the juvenile court to have jurisdiction with regard to the adoption proceedings where there's already been a termination of the parental rights by the court. But I'm not sure I understand why that would be necessary where there's a deprivation, simply a deprivation proceeding pending.
Well, the original...
I'm going to recognize the author to respond, and then I'll call on you, Representative Abrams.
I hope she's going to answer that.
Mr. Chairman, I'm just asking a question.
You yield to Representative.
I'll be glad to yield if you're going to answer it.
I will. Chairman Knox, if you read line 18, so reading from 16 to 18, these are deprivation hearings, proceedings that lead to and result in the surrender of parental rights. So they're both proceedings that result in the termination of parental rights, either voluntarily as a result of a deprivation hearing or as a matter of court action. So my response to that would be, if your concern is, why would juvenile court step in because it's a deprivation hearing? It's only if it's a deprivation proceeding that leads to the voluntary surrender of parental rights, so the child finds themselves in the same situation of having the termination of parental rights and they're in foster care under DFACS, and DFACS wants to be able to go immediately to juvenile court and have the same consistency of court representation.
Mr. Chairman, further injury. I don't want to have a debate about it, but here's my concern about it. Any kind of a deprivation proceeding can lead to termination of parental rights. Mm-hmm. That's the whole point of having a deprivation proceeding. That's the eventual. If you don't, and you've got some pretty strict timelines on that. We enforced upon DFACS a law not too long ago that said they have to do this in a year. Strictly arbitrary. Nobody can say why a year is better than 6 months, 9 months, or 11 months, or 13 months. But that's a law that we impose. So at the end of the 12 months, what happens is typical with DFACS is they get in a big hurry to terminate parental rights, regardless of whether they've done what they're supposed to be or not. You see it happening a lot. So I'd be real reluctant to vote for a new law that would allow them to proceed to take this out from under Superior Court simply on the basis of a deprivation hearing. And then on line 17, now look, Mr. Chairman, if I may.
Yes.
On line 17, I notice it says that the adoption petition is filed in the Superior Court based upon a parent voluntarily signing a surrender of parental rights. I'm thinking probably we need to have both parents sign a surrender of parental rights, or we need to have some other protection showing why we should allow one parent to dispose of the other parent's parental rights, to make a determination on the other parent's parental rights.
You want
to? Whoever wants to answer it, that'd be fine with me. Somebody may know.
Bill, no.
Let me. If I could,
sure.
And most of what I'm saying here is that we ask an awful lot of the Department of Family and Children's Services. I don't think we give them nearly the training or the authority, and right now I think structurally they're just not equipped to do the job we've given them. I don't think you can have, it's sort of like the version of aviation where the FAA is supposed to promote aircraft and at the same time, flying, at the same time they're supposed to promote safety in flying. Those usually are, there's a built-in conflict. We're doing the same thing with DFACS. We're telling them, take people's children away, but restore them to them and make them a better family, but give them to somebody else if if it's not working. I don't think both bodies can do that. I think they need to. That's one of the big problems we're having with DFACS. If we're going to put it on DFACS now to start deciding to go around basically making looking for a forum where they can get the best result that they want, I'm thinking that's a pretty dangerous authority to give them. They can hardly handle the authority they have now. And what leads me to my next question. On line 21, we're saying that the petition previously filed in the Superior Court can be transferred to the juvenile court or withdrawn and refiled in the juvenile court for a hearing to be held within 10 days. I don't know who can do that. Is that only the DFACS that can ask for that and that has the authority to do that, or can either side do that in a proceeding?
May I?
Sure.
Okay. Hi, everybody. My name is Allison Anderson, and I'm with the Office of the Child Advocate. And to answer your question, Representative Knox, it is not DFACS or It is not DFACS that petitions the Superior Court for an adoption hearing. It is the prospective adoptive parents who file the petition in Superior Court. And so it's not giving, this bill does not give any power or additional authority to DFACS. What it does is for children whose parents' rights have already been terminated, we're not dealing with the timelines in that process at all. That process has taken place. The appellate period has passed where parental rights have been terminated. This bill simply picks up once that period has passed and the child is ready to be adopted. In regards to your earlier inquiry about DFACS terminating parental rights at 1 year, actually, the federal law and state law, now in compliance with that, only requires that DFACS file a petition to terminate parental rights if a child has been in care 15 months. It does not require the court to grant that petition. The court, as in all cases, must hear the evidence and make a decision accordingly. And that 15-month timeline has some exceptions and safeguards built into it, so that there is not a premature rush, if you will, to terminate parental rights. That is not what this bill is about at all. It simply is about achieving timely permanency for children who are, for all intents and purposes, legal orphans. They are legal orphans. They have no parents because their parents' rights have been terminated. In regard to your inquiry about one parent voluntarily relinquishing, the rationale behind that provision, and Representative Abrams did a wonderful job explaining that. In addition to her observation, we encounter, or the juvenile courts of our state encounter far too often, children who are in custody of the department by virtue of a juvenile court's order and finding of deprivation. And a parent, and the child may have been placed with a foster family, a relative, or anybody else for that matter, for a year or more. And when it becomes apparent that DFACS does indeed file a petition to terminate parental rights so that the child can be placed permanently, parents can and do make end runs around that process and file petitions for adoption or relinquish for purposes of adoption to some other individual. And it really, in reality, is a charade, because there is an agreement between those people, those parties, the birth parent and the selected putative adoptive parent, that the child will ultimately go home with the birth parent. That can and does happen. We hear about it far too often. I hope that addresses at least some of your concerns and doesn't raise others.
Actually, it does. I think
Okay.
you just sort of part of the, and I'm not sure that this bill is addressing the issues that you've raised. I think those issues are raised by other problems that we have in the code and with how DFACS is working or not working. As far as the termination, since the establishment of citizens review panels in most jurisdictions now, they are putting a lot of pressure on DFACS to make a decision to get something done, because all of that, these time frames came out of 20 years ago, whatever it was, that we decided that there was a CBS documentary that said children are lost in the system, and so we went and passed a bunch of laws that, in response to headlines, and so now we've got all these timelines that everybody's trying to, and the kids are really getting lost in the process now because it's all about me meeting my deadline so I don't get a bad review. And so I know for a fact that there's a lot of pressure on them to get the termination done and to get the adoptive parents. Oftentimes the adoptive parents is being encouraged by, I've been seeing the cases myself personally, being encouraged by DFACS to involve themselves in the case. They put them in the foster care program and then make them the adoptive parent before there's even a termination of parental rights. They're waiting for them to be the adoptive parent. As far as them making the election, the adoptive parents coming in, putative adoptive parents coming in to make this election here with respect to the jurisdiction, I don't know where they get the authority to do that. What standing do they have to do that? They are not in any wise have any legal relationship to that child. At that point that this is occurring in this bill, they are in the custody of the state of Georgia through the Department of Family and Children's Services. They're the only people that have anything to say about that child, just like a parent has custody over their child. When DFACS terminates parental rights, they're then in the custody of the parent for any purpose. I don't know what standing the people have, and I don't think this confers that authority on them to make that election on behalf of the child.
They in fact do have that authority. They are, through their attorneys, they are the ones who file the adoption petitions in Superior Court with the department's approval and sanction, having conducted all the background checks and necessary requirements to approve an adoptive placement of the child with those foster parents.
Thank you, Mr. Chairman.
Vice Chairman Mumford.
I remember this bill from last year, and I know I've heard you say that you worked on it all year long.
Yes, sir.
Actually, in my opinion, you had a better bill last year.
I agree.
The thing that troubles me about this is you still have a filing in Superior Court, and then is it a 10-day limit or something? If
30.
They can't hear it in 10 days?
30
days. If they can't hear it in 30 days, then you go and refile. And
you may. It's not a requirement.
You can't get very much file in Superior Court in 30 days.
But you can't originally file in juvenile.
If I may explain what happened.
What the bill last year said? You could just go file in juvenile court.
Last year's bill.
What it said?
Yes, sir. House Bill 987 was last year's bill, and it was a pure grant of concurrent jurisdiction with no strings or conditions or triggers attached. This bill is different.
But wasn't it only for cases that involved deprivation that had gone through juvenile court?
Yes, sir. That has remained the same.
It wasn't like you could just go file an adoption in juvenile court, right?
No, sir. What is different and what transpired, and I agree with your assertion, and I think we do, the Office of the Child Advocate agrees with you that last year's bill was a cleaner bill. In light of the Superior Court, the Council of Superior Court Judges' opposition to the bill, vehement opposition to the bill, as you know, we attempted to work with the judges and to engage them in dialogue and compromise. And to that end, we traveled the state throughout the summer and fall, meeting with them, ultimately to no avail. And as you all well know, adoptions, and they're very upfront about it, adoptions are the one happy thing they do, and they don't want to give it up. Jurisdiction equals power. That is how it is defined by Black's Law Dictionary. And that is what their opposition is predicated upon. But, be that as it may, we tried to work with them, and this bill represented some form of compromise so that it wasn't a pure grant of concurrent jurisdiction. And if it were true, as the Superior Court judges say, that there are no delays in Superior Court adoption cases, there would be no opposition to the bill, because it would never be triggered under these circumstances. And so, that is why we are here in the spirit of compromise with this version of the bill.
Well, and, you know, I assume somebody said it before, but again, the whole purpose of this is because you believe that there's some delay in getting adoptions done?
There is a delay, yes. Is it a fair statement to say that it's entirely due to delays on the Superior Court's hearing adoptions? No. The problem is a multifaceted one. It's very complex. It involves bureaucratic processes within DFACS. It involves recruitment of adoptive homes for children who are not placed with foster parents who will adopt them. And there are other processes involved. There are appeals. This is one prong of the issue. The other prong of the issue, which is in this bill, but was not in House Bill 987, speaks to the Department's responsibilities in filing for petitions of adoption after termination has already occurred. And in working with the Department, they agreed that they need to do a better job of moving these kids to a permanent home. And so they agreed upon what we believe to be a reasonable timeline to get that process, at least their part of it, done, which is 4 months.
Now, aren't there some children that just are not going to be adopted?
As a child advocate, sir, I don't agree with that premise.
Realistically, you know that there are children that there is not going to be an adoption for those children, correct?
I only know that those adoptive parents for that child have not been found.
All right. Well, does this require a 6-month review, even in those types of cases?
Yes, sir. Existing law requires the juvenile courts to conduct what we call post-termination reviews every 6 months until a petition for adoption has been filed in the Superior Court. As a matter of best practice, some of our judges are now holding these post-termination reviews within 3 months in order to hold folks accountable for seeing these cases through to conclusion.
Further questions for the author or Ms. Anderson? Thank you very much. We had some others that wanted to be heard. I'm going to take those that had signed up in the order Chair deems appropriate.
Oh, just as, if I may,
Sure.
Judge Sammy Jones from Fulton County is on the bench today. He could not be here today. He routinely hears these cases in the juvenile court in Fulton, and I do not believe the CASA folks were able to make it out today, but Mr. Pagel is here from the division. Thank you.
I'm first going to recognize a former member of the legislature who had signed up to speak, Judge Billy Ray. I've not recognized you as a judge because we have a separation of powers here, but you are a former member of this General Assembly.
Thank you, sir. And, those were good years. Mr. Chairman, thank you. I'm here today related to this bill on behalf of the Council of Superior Court judges, and I want to say that I've said it to them privately and probably publicly. You know, we're not here necessarily opposing Mr. Representative Lane at all. You know, he's certainly one of the good guys here, and never has a bad word for anybody. And we're certainly not criticizing his effort. We do oppose the Section 1 of the bill, and I kind of went over a good bit of this, which I'll leave out last week when I came down when it was before the subcommittee. I know some of you were here for that. And I wasn't involved in this process last year at all, so I'm speaking third person based on what I've been told. But for those of you that were here and remember, what I've been told is the main thrust that the Office of Child Advocate had last year with regard to this bill didn't have to do with these perceived delays. It had to do with the desire to allow the juvenile court judge to be a part of the end of this process. Ms. Anderson is certainly correct. Adoptions are a lot of fun. They are a pleasant thing that we do. I wouldn't say necessarily the only pleasant thing we do. I don't necessarily get a lot of pleasure out of sending folks to jail, but I do get some pleasure out of sending some really bad folks to jail on occasion. But this is a very nice thing we do. Typically what happens is judges will, at least in my court, will have these first thing in the morning. Adoptions don't usually last long. It's a picture-taking time. It's a crying time for a lot of folks. It's just a good day. It's just a good part of our day. And so I'm not going to say that's untrue. I personally don't believe, and I think as a council we don't believe that there's a substantial delay. In talking with Mr. Altman, who was here, he's a well-known adoption lawyer in the state, frequently testifies or conducts seminars on behalf of judges about the procedures. And talked with him after the hearing last week. He identified for me some judges that he thought from time to time are delay in hearing these things. If there is a delay, I don't think it's intentional. Adoptions, as you know, are serious because if you get them wrong, it can be detrimental to a family. Those of you that have been around remember the Baby M case in Michigan years ago, where some mistake was made along the way and a child was taken out of an adopted family and was given back to a biological parent. Very hard for everybody, including the courts, I'm sure, if somebody had made a mistake somewhere along the way. And so I think some judges are careful about it. There may be some institutional delay in some counties whereby their procedure is not necessarily to schedule these things right away. They schedule them a few months out. But by and large, I don't think that's a problem. And one of the things that, if the delay is the issue, one of the things that I suggested to the Office of Child Advocate is that they consider simply mandating that we hear these things within 30 days. Now, I can tell you that they won't always be heard in 30 days, and the reason is because frequently, and I'm not saying this in these foster cases, but in many adoptions, the delay is often the lawyers not getting the paperwork in a timely fashion. It is frequent that on the day of the hearing, where I'm going to conduct the adoption, and they're done in chambers, they're not real formal unless there's an objection, that the last documents that are required by statute come in with the lawyer when he's coming in with his family for the adoption, and we have to quickly review it and make sure that the orders are correct or that the background checks. Sometimes we don't even get the background checks that are required until the last possible second. So I think some delays that may occur may be some judges not scheduling hearings until all the documents are in. Typically, my practice is to go ahead and schedule the hearing, and if the documents don't make their way to the file, then we cancel the hearing. But you can address that problem. If that's the issue, you can address that problem with an amendment to the code. It would be a different code section, and I've got some suggested language if that's something that interests the committee, but would just simply mandate that we schedule the hearing within 30 days. Make it a shall. Now, the issue I think that the Child Advocate's Office would raise is say, well, what happens if they don't do it? Well, we're required to honor shalls, and I think typically we do. If we don't, we've got a problem. There is actually a misdemeanor statute that is in law that says that judges can be charged with a crime if they don't honor the shalls that are put forth in the law. So we're supposed to do that. And I think it, more than anything else, that if you put it in law, if there are counties or particular judges that are in places that aren't scheduling these things quickly, that it'll give us an opportunity to go to them, the ones that are these problems, if there are some problems, and say, look, the legislature has acted and said 30 days is when you need to do it, and you got to do it within 30 days. But beyond that, really one of the principal concerns we have has to do with record keeping. Currently, Superior Court clerks are charged with keeping the adoption records, which are under seal, and when cases start going to juvenile court, and I don't imagine it's going to be a flood of cases, but when cases start going, you're then going to start having sealed adoption records in 2 different locations, which can be problematic for adults that were adopted, trying to locate their files and try to find out their history, which is frequently an issue. Beyond that, I'll end my comments. I do want to say a couple things though about the amendment that came from the subcommittee, just kind of a structural thing. One thing I don't understand is the language where it says "or a deprivation proceeding." I don't have a numbered code, but it's on first page 16, line 16, where it says "or deprivation proceeding is pending at the time the adoption petition is filed in the Superior Court based upon a parent voluntarily signing a parental rights termination." I'm not an expert on terminations. Terminations aren't held generally in Superior Court. They're generally held in juvenile court. But it almost seems like that you're setting up a Superior Court judge for not meeting the 30-day window there, because we're not going to have a hearing if there is a pending deprivation action that has not been completed. And that seems to be what that implies, is that it hasn't yet been tied up by the juvenile court judge. And if that's the case, my practice is going to be to transfer the adoption to the juvenile court judge anyway. But for those judges who don't want to do that, they're not going to hold those hearings within 30 days if the juvenile court judge is not finished. So that's just one question I have, one issue, and maybe I just don't understand that part of the law since I don't really practice in it. But the other thing I think that is an issue is this requirement that the juvenile court judge do it within 10 days. 10 days, if a petition for adoption was filed with a juvenile court judge on a Friday, that means by the following Monday week that he or she has got to have the hearing. So they've got to get the petition, go through it, make sure all the information is in there, and schedule it. That would be tough to do in the best circumstance in a one-county circuit. But if you're talking about a South Georgia circuit, which may have 10 counties, or I grew up in Fort Valley, so it was part of the Macon circuit, 3 counties, it's going to be very difficult for the juvenile court judges to do that and to do it correctly. Or it'd be tough for Superior Court judges. It wouldn't be different for us. And so I would ask you to maybe look at that. If the bill goes forward in this form, to maybe take a look at the 10 days. I think that is really quick. That rule about the misdemeanor applies to juvenile court judges too. It doesn't just apply to Superior Court judges. It applies to all of us. So those are my basic comments, Mr. Chairman.
Thank you very much, Judge Ray. Questions for Judge Ray, Vice Chairman Mumford, and then Representative Abrams.
Some in the multi-circuit. It's got about 6 or 7 counties, I think. I'm pretty sure that some of those judges, of course, they sometimes will trade cases off, but it may take them 3-5 weeks to get from one county before they come back again. So they couldn't even get back to the county in 10 days in that circuit. It's common.
Yes, sir. I think that's obviously the truth.
Representative Abrams.
I guess my concern both in committee and here is that the Office of Child Advocate has brought this bill forward in the best interest of the child. And it would seem to me that, and I'd just like your reaction to this, that having adoption proceedings in these very limited fashion, only when parental rights have been terminated and only after these proceedings have occurred, having the court of jurisdiction that heard the prior evidence, having them continue to have jurisdiction making the determination about adoptions, seems to be in the best interest of the child, instead of transferring the body of evidence to the Superior Court, which has not been involved prior to that step in the case. Can you talk to me about why that's not a good idea?
Well, I hate to speak for them. I just know what they told me last summer. They didn't talk to me about delays when I met with them. And this whole issue about compromise, I mean, from their standpoint, compromise is agreeing to the jurisdiction, which we don't. And so it's not that we don't want to compromise. I mean, we don't typically take positions on bills anyway, but it's either jurisdiction or no for most judges. So it would have been great to have compromised if it was really possible. I think their perspective is that, and this is what they said, is that a juvenile court judge ought to be able to enjoy, he or she's been involved in the process, they've heard the testimony, they made a decision to terminate, it might have been a tough decision, and they should share in the joy of the adoption. And I can understand that point of view. I agree more with a point of view that whether this is his point of view or not, I don't know. But Vice Chairman Munford brought up at the subcommittee about that if you've had a contentious proceeding in juvenile court, that it might make more sense that the Superior Court judge who was not involved in all those proceedings then gets to cast an independent view on whether this adoption is in the best interest of the child rather than some other adoption, because it could be competing people. It certainly is not unusual. It's not normal, but it happens that you have competing adoptions for one child, and typically it's cases that have come out of a termination because there may be other relatives that are contending they should adopt, but the DFACS folks have said that this people ought to adopt rather than that person. And so if the juvenile court judge has been involved in the proceedings that led to the termination, arguably it might be better to have an independent judge who wasn't, I think you used the word sold, or maybe, I'm not sure, earlier Representative Randall did as to another bill, that wasn't involved and who's coming into it with a fresh perspective. But I understand their point. I mean, I can understand the desire of the juvenile court judge to be involved in the actual finality of the case, though I don't think the juvenile court judges are necessarily asking for this bill, but I understand that.
May I ask a follow-up question? And this is, I'm less concerned with all due respect to judges, their happiness over the cases they hear. My concern is the best interest of the child. And can you tell me, do you believe that the group that you represent, under any circumstance, would agree to concurrent jurisdiction or would agree to allowing juvenile court judges to be involved in this proceeding?
Well, it's not our decision, it's your decision. But no, I don't. I don't think as a council that the Superior Court judges are going to endorse that prospect. But we're going to do, of course, whatever y'all tell us to.
Okay. Thank you.
Further questions for Judge Ray? Further questions? Thank you, Judge Ray.
Thank you, sir.
Okay. I think, Allison, where did you get off to? You indicated Mr. Hathaway is not here. Judge Jones is not here. Bobby Cagle is here. And Mr. Outman, I did not see him. Okay, so the final speaker will be Bobby Cagle.
Good morning, Mr. Chairman, members of the committee. My name is Bobby Cagle. I'm the Acting Family Services Director with the Division of Family and Children's Services. the division supports this legislation. We've looked at it from the standpoint of the number of petitions that have been filed in the state. Beginning in 1996, the state completed 643 adoptions. As of last year, we completed 1,250 adoptions, 85% of those being foster parents adopting foster children. Our division does acknowledge that we have some problems in our operations, and we're certainly looking at every aspect of the way that we do business. We are desperately trying to bring our state into compliance with the Federal Adoptions and Safe Families Act regulations. We're measured on that in our reviews, Child and Family Service reviews. One of the prescribed standards of that is timeliness of achieving permanence for children, and we are failing at that at this point in time. We feel like this legislation would be an assistance to us in doing that, and we would urge your support for this bill.
Questions from the committee for Mr. Cagle? Representative Abrams.
The judge spoke to issues of record keeping and the difficulty that would be involved in providing access to records. Can you speak to that a bit?
If it's the access to records in the court system, I could not. We do maintain records on all adoptions in the state of Georgia, including both public and private, and that would not be an additional burden for our division.
Thank you.
Further questions, Mr. Cagle? Further questions? Thank you, Mr. Cagle. I'm sorry. Is that Representative Randall?
Yes. It was mentioned earlier that in some cases there may be some contention during the proceedings, especially termination proceedings. Could you address that? Because it's something about another relative may appear, and I worked for DFAC, so I not in that division, but I know how they magically appear. And could you address that and how often that happens?
Well, I can tell you anecdotally that it does happen, and our charge from the federal government is to locate relatives as early on as possible in the process. We have a number of things that we do in order to do that. We've actually begun to use technology to assist us in doing that. Unfortunately, at times, those relatives do not step forward. We cannot locate them for one reason or another, and occasionally we do have people that come forward late in the process, as late as the adoption petition hearing, to apply themselves for adoption.
So would it be safe to assume that in cases like that, when these relatives come out of nowhere after you all have made attempts to contact them and have done research in trying to find the nearest relative, should that even be considered, in regard to switching courts after that's done because of contention with that particular judge? Would you consider that to be a conflict?
I don't know really how to speak to that, to be honest with you. I would tell you that our division's position is that we would consider all relatives at all points in the process, because we feel like the best interest of the child may be served by that relative that comes forward late, and we want to make certain that in the process that we do everything we can to assure that the best interest of the child is served.
Thank you.
Representative Everson.
Chairman, good to see you, Your Honor. In regards to Judge Ray's comments about the 10 days, I was born in the Okmulgee Circuit down in Wilcox County. In your opinion, is that adequate time for the filing?
I have to profess ignorance on that point. I'm a programs person. I'm not an attorney, so I couldn't really speak to that, Representative.
Thank you.
Further questions from Mr. Cagle? Further questions?
I have
I'm sorry, yeah, you told me. Vice Chairman Mumford.
Maybe you're not going to be able to answer this, but maybe you can answer it. My recollection is that a lot of adoptions are filed and then there's usually a Rule nisi that's not filled out at the time of filing. The Rule nisi gets filled out later. Am I wrong about that?
I'm not sure. I don't do those. I don't.
You got an answer?
practices vary. I think also Cobb County, for example, the clerk fills out a Rule 9-5. Cobb County, may be where one of the issues of delay was it may be 80 days out or something, or 70 days. That's just what I was told by Mr. Allen. In Gwinnett, our practice is the file comes up to the judge, and the judge fills in the Rule 9-5. So I guess it's going to depend on where you're at.
But what happens is you file it in the clerk's office, then it comes up to you, and then y'all fill out the Rule 9-5 and send it back to them?
Send it back to the adoption lawyer.
And of course, a savvy judge who didn't want to send his adoption down to juvenile court could fill it out for a time within 30 days. Is it 30 days? Yeah. Within 30 days of filing.
30 days of filing.
And then he could just continue.
Well, that raises the question about, we will continue it if all the documents are in.
Well,
but you could nefariously, if you wanted to just continue it out.
I meant to ask you, but sometimes they get continued because Grandma wants to fly in from Michigan to be there for the adoption.
Sometimes the adoption lawyer who may have other practices have court conflicts too. You can't come.
Further questions?
Mr. Chairman.
Further questions? Thank you, Mr. Cagle.
Thank you.
Any final comments you wish to make?
Yeah, just about 30 minutes. Your Honor.
Sorry. You're not recognized for that.
No, just a couple. I think some of the comments made, there are courts where these adoptions are not scheduled within 30 days or not heard within 30 days. And in those rare circumstances, I think this is a good bill that allows the adopting parents an alternative to go to juvenile court and to have the adoption petition heard. So I think that part of the bill is good for the children to bring some permanency to them. And the second part, Section 2, that requires the adoption petition to be filed within 4 months after the disposition order, I think is even more important in the bill, perhaps. So I think those two parts together make it a good bill, and I would request a committee to do pass.
Any final questions for the author of the bill? Well, I'll echo the kind comments that have been made about you, Representative Lane.
I don't know if that's good to have a lawyer called nice or not, but
if we don't call each other nice, then
that's true. That's true. That's true, Mr. Chairman. I appreciate it.
Any final questions? Questions from the committee? Comments from the committee? Chair recognizes Representative Byrd.
Yes, sir. Thank you for this piece of legislation. My parents are adoptive parents, and they also were foster care. But I have grave concern that this may be too easy to terminate a parental rights. So I would like this to be tabled so it can be further studied.
I'll second that.
We have a motion that House Bill 599 be put back on the table. Is there any discussion of the motion? Representative Abrams.
My parents, too, are foster parents, and they've actually had to go through the termination of parental rights proceedings, not here in Georgia, but in another state. And the complexity of terminating parental rights should not be undercounted. This bill only takes effect once those proceedings have followed their normal course. This is not new law that changes the ability of the courts to terminate parental rights. It only follows existing law, and it only permits the juvenile court to step in at the second phase. I mean, much in line with, although I think a dramatically different philosophical vein, if we think about our conversations yesterday about the verdict phase and then the sentencing phase, this is the sentencing phase. This is after the verdict has been entered by the juvenile courts. It's after the verdict has been determined about parental rights, whether it's as a consequence of a deprivation proceeding that led to the voluntary termination of parental rights, or as the termination by the juvenile courts. My concern is that this has been ongoing for 2 years at least, and the continuing delay, the impact that this has on foster care and on parents who really want to be legitimate parents to these children, this only permits these children to have better access. I have little regard for judges wanting to feel good about the court cases they hear. That's not of interest to me. I have less concern about record keeping. We can find all the records we want and we can keep them when we need to. What is most of importance to me is the welfare of the child, and this is a bill that, in a state that has consistently underserved its children, will allow its children to be served better for at least this proceeding. And so I would strongly urge us not to support this measure, to table, and would instead move for due passage at the appropriate time.
Representative Abrams, I'm not going to recognize you for that motion at this time, and I think you understand why. I think that if the will of the committee is to not move forward, I think that the more appropriate way to do that would be to vote for the motion to table, as opposed to a negative vote on a due pass. But I will keep you in my line of sight. Representative Bearden.
I was on the same line with Representative Abrams, and if it gets to that point, I'd be more happy to second that. So we'll go from there. So.
Okay. Further discussion. This is on the motion to table. Any further discussion? Any further comments? Hearing none, we'll call the question. All in favor of tabling House Bill 599, please indicate by raising your right hands. Okay. All opposed? Motion failed. Motion to table has failed. Representative Abrams, you're recognized.
As substituted.
Second.
We have a motion made by Representative Abrams, seconded by Secretary Bearden, that we give a due pass recommendation to House Bill 599 by committee sub. Is there any discussion on that motion? Any discussion on the motion? All in favor of the motion to give a due pass recommendation to House Bill 599 by committee sub, please indicate by raising your right hands. All opposed? The motion has been adopted on a vote of 5-4. Thank you, Representative Lane.
Thank you.
Okay, here's where we are. We're going to adjourn this meeting at 11:35. Between now and I want to take two short bills next, and I usually take my bills last, but because they're short, and I got a feeling the remaining two after that will not be. Are you down to about 3 minutes on your bill? I want to take, and the library folks have been here patiently all day, yesterday and today. So what we're going to do is we're going to take House Bill 226, then House Bill 653, and then we're going to take about a 2-minute recess for me to confer with the subcommittee chairs, and then we'll make further announcement on the remaining two bills, which will be House Bill 26 and House Bill 336. Turn the gavel over to the Vice Chairman.
I'm going to call up 226.
Yeah.
Call HB 226, Chairman Ralston to present the bill.
Thank you, Mr. Chairman, members of the committee. I was asked by the city attorney for the city of Sandy Springs, who some of you may also know as the other judiciary chair, Representative Willard, to and also by the Speaker Pro Tem, to carry House Bill 226. Very briefly, the background to this bill resulted from a decision by a federal court last February of 2006 that struck down the constitutionality of Georgia's obscenity statute. Basically, they made a finding that it was overbroad in terms of its restrictions on advertising the sale of certain merchandise. I have a copy of that court case if any of our legal scholars wish to read it. The case, Chairman Franklin may have made a field trip since it came out of Cobb County. The case is This, That, and the Other Gift and Tobacco versus Cobb County, Georgia. So there was interest from some of the metro areas in resuscitating our obscenity law, and what you have before you is LC 292822S is a committee sub to House Bill 226, which does that. There was some concern raised by the public librarians, and I asked them and Chairman Willard and others who were interested in the bill to get together, and my understanding that everybody's comfortable with this version of the bill. I'll let them speak to that in more detail. Certainly that was my intention to have them be that way, because it carves out an exemption for public libraries. But basically this eliminates the more targeted or more narrow definition of who the information could be disseminated to that the federal court found to be problematic. I think that it's a good bill in that it puts this law back on the books and upholds our traditional family values in this state, and I would ask favorable consideration.
Are there any questions for the author of the bill, Mr. Franklin?
I do have a question as to why we would be exempting a person working in an official capacity in a public library from the provisions of prohibition.
Mr. Chairman, it might be appropriate. Stephen Neff with the libraries had signed up to speak, and if it's okay with the chair, it might be appropriate to have him speak, and I think he can address that.
And if he doesn't, if I could
Sure.
follow up.
Mr. Neff. Mr. Beach, you want to come up as well?
Yes, I was certainly going to invite him. Mr. Chairman, and members of the committee, my name is Stephen Neff, and I actually work with the Georgia Council of Public Libraries. And the Georgia Council of Public Libraries consists of all the directors across the state in each of the public libraries, and they have asked me to come and meet with the chairman and Chairman Willard on this bill. They did have some concerns with the exemption piece, Mr. Franklin, and their concern was that there's been certain cases where that people have come to the public library and wish to have certain books removed from that library that they felt obscene or they felt inappropriate. Those specific cases typically end up in court. Hopefully they can be handled by the library directly and handled by the board directly quickly. But there were some cases in which they have ended up in court and gone through significant amount of trouble, in which the libraries would try to like to avoid that in the future if at all possible. I use as an example, we had a library director that was here with us yesterday from McDonough. And she had an example of a parent that had come to her and asked to have a book removed from the library, and after some investigation she looked into the book, and the book was indeed an anatomy scientific education book, in which you all may recall, but they have the nice little clear pieces that come out that talk about the nervous system and the various systems and parts of the body. And of course it did also include the anatomy of the body, and they thought that that was inappropriate to have it at the library. And I think that's the kind of thing that we're trying to avoid in the future. I'd like to ask Dr. Veach to speak as the public librarian director, and he can possibly shed some more light on this.
Well, thank you, Mr. Chairman. We appreciate the willingness of the bill's author to consider this exemption. We have library staff in 370 libraries who are checking out 40 to 50 million books a year to the public. Any one of those books might be considered obscene by somebody, whether it's for religious reasons or whatever. And because you have already exempted employees of institutions of higher education, and because public libraries in this state are considered integral components of education in Georgia, we felt that that was appropriate for an exemption. We have the 370 public libraries in this state, as I said, check out tremendous numbers of items, any one of which could be complained about by somebody somewhere. And we felt like that those employees, whether they be librarians or part-time clerks, shouldn't have to have this law hanging over their heads and be accused of violating it simply because they checked a book out to somebody that somebody decided was not an appropriate book or was possibly obscene under this law. So, and that has to be adjudicated, of course. So we felt that with the provisions that public libraries already have in place, their long-standing rules, their long-standing policies, their long-standing procedures that that the public can use anytime they feel like a book has been chosen for the library and is inappropriate. There's a very distinct procedure in place for that challenge, and very honestly, we just don't want to see all of those hundreds of good, hardworking librarians and library staff people under this cloud because they are not exempted under this provision. So that is the reason that I think the Georgia Council of Public Libraries has come forward working with the author of the bill to provide this exemption so that they're simply not under that cloud of suspicion just in case a person does object to a book. And there are many people who will object to a lot of books that are in public libraries, but that's, you know, another story for another issue, because there are people with different belief systems and different moral values, and those do pop up from time to time within the public library service. So that's really the reason that we want to be able to exempt the public librarians, is because there already is a process in place for this. Thank you.
You're running the meeting.
That's right. Any other questions? Sorry. Yes, Tom. Mr. Knox. Thanks.
I'm curious about these two exemptions here. One of them is for a person associated with student higher learning. The other one is that you're proposing is for a person working in an official capacity in public library. I started looking at number 2, wondering whether that a person working in an official capacity in public library, does that mean that he's exempted even when he's not working in a library, if he's at home, in his own little library at home? Or that would certainly not be the intent, Mr. Chairman.
Yeah.
I don't know what maybe the author can help us, but the understanding would be on number 1 then also, because the person associated with an institution of higher learning sounds to me like that's just a status exemption there. It doesn't have anything to do with what he's actually doing or when he's doing it. I'm wondering if that's what our intent is. I think that would be a fair
Yeah. Sure.
Teaching.
It's been. I'm going to call on Sally to help me out here. That's current law now. And I think the way I read it, Chairman Knox, is a person associated with an institution of higher learning, either as a member of the faculty or a matriculated student teaching or pursuing a course of study related to such material. So I think the teaching or pursuing, I think that qualifies that in my view at least. And that is current law. Well, I think he would be working in an official capacity.
That was our intent when they were working in the capacity in the library or library agenda.
Yes, representing the library in their course of work in serving the public.
Thank you, Mr. Chairman.
Thank you. I recognize Mr. Franklin for a motion.
Thank you.
As the library folks have answered my question the way I was afraid it would be answered, I think it is important that since, at least in Cobb County, nobody operating our libraries are elected. They're not accountable. And yet our tax dollars are used to put material in the libraries. I think to protect our communities, I move to delete line 29 from page 2 and renumber the subsequent section or sections accordingly.
Is there a second to the motion?
Second.
There's a motion and a second. Any discussion of the motion?
May
Yes, go ahead.
I certainly concur, I think, with the position that I think Chairman Franklin is taking. I'm not sure that getting at this issue through this amendment is the proper way to address what may or may not be the problem. So I would ask for a negative vote on his amendment.
Anybody else want to speak to the amendment? I would like to speak to the amendment also. I serve on my local library board, and I think I have for about the last 15 years. Our library board in Rockdale County is appointed by elected officials, except for a few members that are appointed by a private organization that originally founded a women's club that originally founded the library. I can assure you that there is a great deal of care taken in the materials that are selected for public libraries. You know, from time to time there may be people who object to Catcher in the Rye or some of the volumes that might be in a public library. I know there was recently a controversy in Gwinnett County about Harry Potter books, but I would say that by and large our libraries do a very good job of keeping an appropriate selection of materials and not having materials that are inappropriate. While I appreciate the amendment, and I'm certainly not opposed to the idea that I know what Mr. Franklin wants. He wants to make sure that obscene material is not in our public libraries, just as I do. I also think that from time, if we have this on the books, that without this cutout here for library personnel, somebody who does object to Catcher in the Rye, which I think is at this point probably entered the mainstream of American literature, could come in and demand a warrant and arrest a librarian for checking out Catcher in the Rye. And I really don't think we are to the point in this state where we want to go down that road yet. So I would ask the members of the committee to vote against the motion, the amendment. Yes.
Mr. Chairman, I'd like to be recognized for a substitute motion.
I don't think we can have a substitute motion. I think there's a motion and a second, and I think we have to vote on that first. I will recognize you once we have the result of the motion that is on. Now, I guess the author of the motion could accept an amendment I believe, if you want to try and do it that way.
It wouldn't be, I don't think, a friendly amendment, so I wouldn't even I wouldn't even request it. It's a scrivener's correction actually, but if he doesn't want the provision at all, it corrects the provision. That's all. So.
Okay. All right. With that, is there any further discussion of the amendment? All right. There has been a motion and a second. All those in favor of the amendment of Representative Franklin, which is to delete at line 29 the number 2, and a person working in official capacity in a public library, semicolon, or, and then renumber. All in favor of that motion, please signify by raising your right hand. All those opposed, please signify by raising your right hand. It appears that the motion to amend has failed. Do you have a motion?
I do, Mr. Chairman. Actually, I'd like to start with the point of parliamentary inquiry, if I may.
Sure.
Does the chair know whether the author of the bill would consider as a friendly amendment putting the word while in between person and working on line 29 at page 2 so that it reads a person while working in an official capacity in a public library? Or
I would like to give you an answer as to what the author of the bill thinks. but I'm afraid to, so I'm going to let him respond to that.
I have no objection to that.
Mr. Chairman, I'd like to be recognized for a motion, please.
All right, are you, you're going to make a motion to make that amendment?
Yes, sir.
All right, go ahead.
Mr. Chairman, I would move to amend at line 29 on page 2 by inserting the words while, W-H-I-L-E, between person and working, so that the line would now read, number 2, a person while working in an official capacity in a public library, semicolon, or.
Okay, and that's at line 29.
Yes, yes,
okay.
sir.
All right, does everyone understand the motion? I believe it's been accepted by the author and will not require a further vote. Is that anybody object to the author accepting that friendly Scrivener's amendment? All right, is there any further discussion on this matter? If not, I would like to know the will of the committee if someone has a motion. There's been a motion to pass. Second. Is there a second?
Second. On substitute as amended.
On substitute as amended. Thank you. Is there a second? All right, all those in favor of a do pass motion on this bill, please raise your right hands. All opposed? All right, it seems to have passed. Thank you very much, Mr. Chairman.
Thank you, Mr. Chairman.
We appreciate your consideration.
Thank you very much, Mr. Chairman, members of the committee. If I could find my committee sub, which Diane had for me. I have for your consideration House Bill 653 by committee sub, and I'm working from LC 292829S. I was prompted by the experience of the people in Boston several weeks ago over the Turner Broadcasting issue with some what appeared to be, or what could have been construed to be, hoax destructive devices, to look at Georgia law on this issue. And I'm not here today to say whether it was proper to have viewed those boxes as hoax devices or not. I think that has to be determined on a case-by-case basis, or whether or how the individuals involved should have been charged on that. But what I did want to do is look at what we do in Georgia on this now. And it occurred to me that we're past the era where we can send a couple of 3 guys and a robot out to detonate these devices or check to see if they can be detonated. I think what this bill recognizes is that the world changed on September 11. We now have a Homeland Security Department at the federal level. We have Homeland Security Agency here at the state level. Local law enforcement is being called upon, whether it's police, firefighters, EMS personnel, to respond to potential situations. And when they respond, that obviously costs money. So this is not really the Cartoon Network bill. This could have been the Covington Pipeline bill, which is covered in today's paper, where a hoax device was put on a oil pipeline near Covington. And I think that the people who investigated that put it best, that when you have that kind of situation, you're diverting resources that properly ought to be used for other things. But we have to respond unlike and more extensively than we did prior to 9/11. So what this bill does is 2 very simple things. It, number one, makes a little tighter on page 1 in subparagraph A the definition of what constitutes placing a hoax, bomb device, or destructive device. And in subparagraph B, I think it makes clear that this is in fact a serious offense. Under the old definition, it was a little convoluted because it was a felony, but you couldn't be sentenced to more than a year, although you could be fined up to $10,000. And I think this makes clear that it's a 1 to 5, keeps the fine language as it is in current law. And I think basically by tightening that up and by strengthening the punishment provisions, we're saying that it is a crime to scare people. And then in subparagraph C, we recognize that the court can consider the cost of responding to one of these incidents in assessing restitution. I know that was not an issue in Boston, because my understanding is that the Turner folks stepped up to the plate and paid about $2 million, I think it ended up being, for the expense that the city and its agencies incurred in responding to that episode. I commend them for doing that, but it occurred to me that I don't want to be at the good graces of people volunteering to do that in the future if they don't choose to do that. But this gives our courts a way to assess that as part of the restitution. So, Mr. Chairman, I'd be happy to answer any questions and ask the committee's favorable approval.
Any questions from any members of the committee? Mr. Levitas, I saw first. I'll let you.
Mr. Chairman, thank you for introducing this bill, and I think it's a great one. I'm just curious, on line 5, why we're limiting it to only public safety agencies. Why wouldn't we want any local county or state agency that's involved in having to deal with it, whether it's they have to rope off an area and there's a lot of stuff to clean up afterward, whatever the incident is. I'm just wondering, was there a reason that we're I'm sorry, line 5 on page 2, last 2 words. Was there a reason for limiting it to public safety?
Only because I think it's public safety agencies, whether it's police or fire, EMS, that respond to that. I mean, you know, if it's the will of the committee to strike that out, and I'm not sure what other agencies would be included, but I mean, I wouldn't. I'm neither asking for nor would I oppose an amendment there.
Mr. Chairman, may I permit one follow-up?
Sure.
And along those same lines, would the author of the bill consider including at the end of line 7 the phrase "but shall not be limited to," where it says such damages shall include the provision of police, fire, rescue, and emergency services, just so that we include those expressly and then catch any other agencies that might be involved in responding to this?
I have no objection to that.
At the appropriate time, and that Mr. Chairman might be
So that's on line
recognized.
7. It would such damages shall include but not be limited to.
Yes, comma, but not be limited to, comma.
All right, that's been accepted as a friendly amendment by the author. Are there any objections to that amendment? If there are no objections, that amendment is accepted. Any other, Mr. Franklin, you had a more of a question.
Thank you. I noticed, and I'm very pleased to see that 3 words were dropped from the original bill. That so that it actually has to be the intent to leave the impression that we're dealing with either a bomb or something, whether it actually is or not. And I'm grateful for that. I would hate to have someone leave their box of dynamite hot hamburger patties behind on the park bench, and someone think that really is dynamite or something, and when they had no intent of causing a scare. And so I'm glad for that, and just want to make sure that there's nothing else in here in that third from the last word on line 13 of the first page, the intent. That this does reference the intent to cause another to believe, and it's not just cute little artsy wires coming out of your lunchbox that you left in the break room. But it's only the intent. And do you recall if the Cartoon Network, were they simply advertising for their program, or were they intending people to think that what they had up on that sign was a bomb?
I think their defense now is, and I don't think the case has been completed, so I don't want to prejudge it. Mm-hmm. And I haven't been.
You're not going to be on that jury, probably.
I'm not going to be on that jury. Might be the one juror or two. My understanding is that they are taking the position that was simply a promotional campaign.
Right.
I don't think there's any real suggestion now that wanted people to think it was a destructive device. But
and that being the case, even the new language would not apply in that. Because you have to have been convicted. So if their defense prevails, where there was no intent, and that it was just purely promoting their programming, then the provisions of this new Section C would not kick in because they would not be convicted.
It would only kick in if they were convicted or pled guilty. It would not kick in unless and until that happened. And the intent language was modified. I mean, it's as the current law is. I took out that other to improve the bill. So there has been no change whatsoever to intent. So now there has to be, as there always has to have been, the intent to cause someone to believe that these are destructive devices.
Thank you. And at the proper time, Mr. Chairman, I'd like to be recognized.
All right. I think now's the proper time. Is there a second? By substitute as amended, is there a second? There's a motion and a second. All those in favor, please raise your right hand. Those opposed, matter passes. She's counted as do pass.
We're going to take about a 2-minute break. I need to confer with Chairman Knox and Chairman Mumford, and I'll be right back to make an announcement.